Hello, everybody, and welcome to the North County Estate Planning Council's May meeting. My name is Ollie Ben. I am the Director of Philanthropy for the Jewish Community Foundation here in San Diego, and it's a pleasure to continue hosting these online sessions until we are able to get back in person, which I'm sure Bill is going to provide a little bit of additional information on today. The Jewish Community Foundation has historically been the largest grant maker in San Diego, and we really take what we consider to be a concierge approach to philanthropy. We consider our professional advisor clients to be our partners, and we provide a lot of advice and always welcome our partnerships with professional advisors like yourselves. We work on complex assets, donations. We've had lots of questions recently about donations of real estate, which is always a very interesting area, and something that we have considerable experience with. And one of our programs that is launching, and Bill has been doing a really nice job of promoting. Thank you, Bill, for doing that. This will be the last time that we spam you for a year about this, is our Trusted Charitable Advisor program. This is a way, really it is a phenomenal network of all kinds of professional advisors in the San Diego area. It's meant for, it's not really a 101 program, it's meant for higher level professional advisors. And it's a fantastic way to be able to open up conversations with your clients about philanthropy and charitable giving. And oftentimes it's just about the language you use, and there's just a toolkit that we offer that's provided very invaluable for a large number of lawyers, accountants, estate planners, etc. in the San Diego area. And just so you can see, this is part of the network of graduates of this program. Most of the major firms in San Diego are represented there, and we would encourage you to join up and sign up for this great program if you haven't already. If you would like more information, you can reach out by email, or you can just enter something in the chat and we will be happy to reach out to you. You can also go to jcfsandiego.org/TCA, Trusted Charitable Advisor. Additionally, we offer this, we've been sending out for a little while now, and it's really getting quite popular, this curated reading list, articles that you can send on to your clients when you find them interesting. It's just what is interesting to us and what we are reading in the areas of philanthropy, local nonprofit issues, and people have been asking us recently, like, hey, how can I get my article featured? Feel free to send along any interesting articles. If you're not currently receiving our Philanthropy Insider email, just again, feel free to drop a message in the chat or shoot me an email, and we would be happy to add you to that list. So with that, thank you for your time, and thank you for your participation in these amazing events. And with that, I will turn it over to Bill.
Good morning, everyone. Welcome to the May meeting of the North County Estate Planning Council, San Diego. Thanks so much, Ollie. We certainly appreciate your hosting the Zoom webinars that we've been putting on, and especially appreciate you reaching out in April of last year, volunteering to make this all happen. So thanks so very much. We have a great program today. Our hot topic ladies, Katie Swafford of Withers Bergman, Kristen Shepard of Goodwin Brown, and Roberta Robinson of Robinson and Wilson will give us a thrilling update on what's going on, federal and state laws, regulations, rulings, and so forth. Just have a few announcements just to go over. As Ali kind of mentioned in talking with many of you, we are all anxious to get back together in person. I've been talking with Fairbanks Ranch Country Club, and of course they're on the opposite end of needing to be careful. They're actually good on dealing with golfing and use of their restaurants and such. They are still skittish as to what's allowed or what isn't. Supposedly we have a June 15th date of opening up the state. we'll see, but I'll keep you posted as far as future possibilities. Definitely want to have you put on your calendars our next meeting, which is, they're always on the first Tuesday of the month, June 1st. We have a webinar on combining advanced insurance and charitable planning designs, strategic tax and estate techniques for high net worth individuals with John Kramer of WealthPoint LLC. John is a top-notch advanced life insurance planner with a passion for philanthropy, and he's going to present some information combining the two. As Ali said, May 13th, we've got the kickoff of the JCF's Trusted Charitable Advisor Program. Certainly highly recommended. It just supplements your background in charitable and philanthropic discussions with your clients. July 6th, we've got Laurent Roux of Gallatin Wealth in Wyoming, and he's going to be covering the unique world of Wyoming LLCs, Wyoming private trust companies, and their asset protection trust world. An alert for all of you. The San Diego now has a chapter in the Advisors in Philanthropy organization. This is a great way to be much more focused in your planning relative to philanthropic discussions and charitable discussions. Claudia Ehrlich is the president, and Marty Dutch, who is president of the AIP National, are behind that. Marty's originally out of the Orange County AIP program. So definitely let me know. You all have my email address, and we'll get you connected if that's of interest. Certainly want to let you all know that do go to our website, www.ncepc-sd.org. David Jacobs has been really killing it as far as making that a dynamic website, and also interrelating it to the LinkedIn platform. So kudos to David for making that happen. For those, as you've registered for today, you'll note that you have the opportunity to participate in the council's trifectas that's led by Pete Tentler. Certainly do that. I was a little bit missing in action for the first few months of 2021, but we're back to rocking on that one. And I think it's certainly good to note that this is a way to deepen relationships in small groups with others in the council. So highly recommend that. I want to introduce you all now to Valerie Medina of Trust Properties USA. She's our sponsor for this meeting. And with that, Valerie, I let you take it from here.
Thank you. I'm going to share my screen here. Am I sharing, Ali?
Yeah. Yeah, if you just hit slideshow, then it will go full screen.
Got it. Okay, can you see that?
Yeah.
Perfect. Good morning, I'm Valerie Medina. I am a broker associate with Trust Properties USA, and my company specializes in probate and trust real estate. We've sold over 600 probate and trust estates. We've been in business for 20 years. We're A+ rated by the Better Business Bureau, and we love our client reviews. Our presence is in Southern California, with the goal to have a presence in the entire state of California. But currently our offices are in Ventura County, LA County, Orange County, San Diego County, and we just opened 2 new offices in Riverside County. So the services that we provide, we do a fix and sell strategy. I call it the family flip. We provide every service that the real estate needs, every contingency. A few are trash outs and estate sales, evictions and lockouts, abandoned car removal, rekey and security measures. And we do this all at zero upfront cost. My company doesn't charge a penny for the fronted cost. We just get the fronted cost back at the close of escrow and charge a regular realtor fee. Here's one of my latest case studies. This home had a before value of 630,000. It was not a hoarding case. It just had deferred maintenance and had a lot of stuff in it. So I took on the project, cleaned it all up. Contractor put in a new kitchen and did some repairs. We increased the value to 770,000, and the repair cost was over 50 grand. That amount of money we get back at the close of escrow, and the estate still gained over $88,000. The administrator and her family were delighted, to say the least. Also, my company provides free services to professionals. So we will pull grant deeds. We do desktop evaluations. We provide date of death broker price opinions, and anything that you may need as far as valuing property, we can help you. I'm Valerie Medina with Trust Properties USA. Here's my contact information, and I'll also put it in the chat. Thank you, Bill.
You bet. Thank you, Valerie. Appreciate your sponsorship and the great work that you all do with dealing with the real estate that we and all our clients are dealing with. Without really any further ado, I'm thrilled to introduce to you all, I call them our hot topic ladies. Many of you know them from them keeping us up to speed when we were meeting in person. As far as changes in federal and state laws, probate court proceedings, California cases. So looking forward to giving them an opportunity to give us this update that really will become an annual one. They were going to be covering stay ahead of the curve, hot topics in trust and estate law. Our ladies, Katie Swafford, Kristen Shepard, and Roberta Robinson are really going to challenge you with some of these questions that they're going to cover in their program. Taxable gifts. When is a loan a taxable gift? Tax me now or lose me forever. In light of the 99.5% Act, should estate tax related to recent deaths be incurred now or deferred until surviving spouse's death? Call me crazy, the impact of mental delusions on testamentary capacity. Dad always said I was his favorite child. Evidence of lifetime gifts used to force post-death equalization of the estate. Conservatorships. Can the probate court order conservatees to visit with persons against their will? Our speakers today, Roberta Robinson is an attorney with Robinson and Wilson in Rancho Bernardo. Very experienced attorney that I've known often and talked with often over the years. Roberta's practice is one that focuses on helping her clients establish living trust, wills, financial powers of attorney, and advanced healthcare directives. How to deal with probate and other matters. She's taught a number of different courses in the state and the local bars. She received her BA from University of California at Irvine and her JD from USD School of Law. Kristen Shepard is a partner with Goodwin, Brown, Gross, and Loveless, LLP. She's been a partner for a number of years. Definitely very experienced and broadly practiced across the world of probate and trust administration, conservatorships, and estate planning. Enjoys representing fiduciaries, professional, institutional, and non-professional. I'm going to kind of stop there. You've seen her information in our meeting announcements. Has her JD from California Western School of Law, very active in the professional community, certified as specialist in estate planning, trust, and probate law, and she's a regular speaker and author. She's was a super lawyer rising star in 2016 and continues to be a San Diego super lawyer to this day. Katie Swafford is a partner with Withers Bergman in San Diego, as well as and works out of the San Francisco office. She focuses primarily on the trust, estate, and inheritance disputes team at the international law firm of Withers Worldwide. Her world is definitely focused over on the fiduciary litigation side of things. Very, very experienced, and if you've tootled through her bio that's been part of the meeting announcements that have gone out, prolific writer, speaker, active in many different areas, including the council, the La Jolla Bar Association, Probate Attorneys of San Diego, and so on. And just the one personal touch, she's of course quite proud to be a mother and with 4 children, keeping very busy with everything from soccer and gymnastics and what have you. And without any further ado, I turn it all over to you all.
Thank you, Bill, for that nice introduction. Hello, everybody. Thank you for being here today. As you know, I'm Katie Swafford. I am a trust and estate litigator at Withers Bergman. And I know Roberta and Kristen joined me in saying that we've missed presenting to you on hot topics over the last year. We hope that once the pandemic subsides and we're able to meet in person, we'll be able to resume giving our presentations to you. But in the meantime, the purpose of today is meant to catch you up on the last year because we haven't been able to present on hot topics to you over the past year. And hopefully we can get you caught up today. We're going to be talking about case law and tax issues. And some of these tax issues, as you know, are very, very current. So I think you'll be very interested in hearing about them. Just one quick comment. We're happy to take questions, and you're welcome to put your questions in the chat. However, we will probably wait until the end to answer the questions so as not to be disruptive to our presentation, and we want to make sure we can finish today. So without further ado, the first case that I'm going to talk about is the conservatorship of Navarrete case. And Ollie, you can skip ahead a couple slides. Yep, here you go. All right, so the conservatorship of Navarrete case was a very interesting and sad case. What happened here is the proposed conservatee suffered from cerebral palsy, a developmental speech and language disorder, anxiety adjustment disorder. She previously had a kidney transplant and she had other issues. And her mother, who was her primary caregiver, brought a petition to be appointed as her probate conservator of the person and estate. Her father and her older brother objected to the mother's petition to be appointed as conservator, and the older brother filed his own petition to be appointed as her probate conservator. During the course of the case, it came out that the proposed conservatee accused her father of raping her and sexually assaulting her. And the proposed conservatee had reported this consistently numerous times to persons such as her mother, her younger brother, and her therapist. So when the case got to trial, other persons testified about what the proposed conservatee had told them. And when it came time for the proposed conservatee to testify, The judge called her to interview her, but did not swear her in as a witness because the judge wanted to determine whether she was competent to testify. And the judge went on to ask her a lot of questions. She was able to answer, for the most part, many or most of the questions correctly. Although she had problems communicating and formulating her words, she was able to communicate and to differentiate the truth from a lie. Regardless, that for one reason or another, the judge decided not to swear her in as a witness and decided that she was not competent to testify at trial. The court went on to grant the conservatorship and appointed the mother as the probate conservator of the person in the estate of the proposed conservatee. However, the probate court took it one step further and said that he thought that it was more probable that the dad had not raped and assaulted the proposed conservatee, and the judge just kind of thought that it was in the proposed conservatee's best interest to reconcile with her father. And so the probate judge ordered visitations between the proposed conservatee, I should say conservatee now, and her father, which she vigorously objected to at the time of that decision. And by the way, when she was testifying, or not testifying, I should say, when she was interviewed by the judge, it was clear that she was extremely fearful of her father and she did not want anything to do with him. But still, the judge just decided on his own that he thought it would be in her best interest to reconcile with her father. So she appealed, and the Court of Appeal overturned the decision. The Court of Appeal determined that while a probate conservator is vested with very broad powers, a conservatee still retains certain personal rights and has personal autonomy. He doesn't divest, the conservatee doesn't divest him or herself of all personal autonomy just because there's a conservatorship in place. In particular, a conservatee still has the right to receive visitors, telephone calls, and personal mail. They remain in control of those things unless there's a court order in place saying otherwise. And here, what the judge did, he was really infringing upon her personal rights and her right to personal autonomy. She is, as an adult, has a right to decide who she wants to visit with. And you can't force two adults to get together and visit with each other if they don't like each other. And certainly we don't see orders coming out of the probate courts forcing kids to visit with estranged parents when they don't like each other. So the situation is no different with the conservatorship in place. And the court determined essentially there was absolutely no statutory authority for this order, and the courts cannot force a conservatee against his or her will to visit with someone. Now, the outcome would be different if we were in family court with a minor. Minors can be ordered by the court to visit with relatives, but that's not what we have here. Here we have an adult, and you can't force an adult to visit with someone that they don't want to visit with. This case was interesting to me because as a litigator, from time to time, we do see conservatorship petitions filed for the purpose of attempting to get visitation between parties. Conservatorships are really supposed to be a last alternative. And when someone has an estate plan in place, you want to use the estate plan to govern their affairs. And really, the conservatorship is supposed to be used when there is no estate plan in place to cover those things that would otherwise be covered by an estate plan. But we do see from time to time petitions filed for this purpose of visitation. And back in my early days, when I was a trust and estate litigator in Los Angeles, my colleague filed a conservatorship petition on behalf of the old star of the Columbo show. You may remember Peter Falk, and we represented his daughter. I did not work on the case, so I don't remember the details or nuances, but I remember it was a really big deal because my colleague was able to get a conservatorship over Peter Falk so that his daughter could visit with him. Given this case, I don't know that that would happen today. So we need to keep in mind going forward that where we have a parent and a child who are not getting along, at least with respect to conservatorships and probably with respect to all types of probate proceedings, a court cannot force unwanted visitations between the parties. Okay, Ollie, let's move on to the next slide. The next two cases I'm going to talk about have to do with reformation of a will. And you may be familiar with the term reformation, but just to briefly explain, we use that when there's a mistake in a document and it needs to be fixed. So basically, we're reforming the document to make it correct. And back in 2015, we have a seminal case by the California Supreme Court called Estate of Duke. And in that case, the court held that where clear and convincing evidence establishes both a mistake in the drafting of the will and the testator's actual specific intent at the time the will was drafted, denying reformation would defeat the testator's intent and result in unjust enrichment of unintended beneficiaries. So keep that in mind. That is the rule that we have now pronounced by the California Supreme Court on reformation of wills. So now we're starting to see the lower courts and courts of appeal interpret the Duke ruling, and that's what we have here in the next two cases. So what happened in the Willikin case is this was a second marriage, but a long-term second marriage. These husband and wife were married for like 30 or 40 years. Both had children from their prior marriages and owned separate property from their prior marriages. And here the wife had a house in Santa Barbara that was her separate property and that she rented out. So at some point during the course of the marriage, the wife went to her friend, who was a legal assistant in an estate planning attorney's office, and asked the friend to prepare a trust for her separate property house in Santa Barbara and a deed to transfer the house to the trust. She went behind her husband's back. He did not know that she was doing this, and she basically did it with her son. And the purpose of the trust, she told the legal assistant, was to ensure that upon her death, her separate property house goes to her sons. So when she met with the legal assistant, there was no discussion at all about her community property, about bank accounts, about other investments, life insurance, anything. The only discussion was with respect to her separate property and her house. The wife also had one discussion with the estate planning attorney. She only talked to the attorney once. And the attorney also testified that they only talked about her separate property house, not anything else, not community property and the like. So during the course of these meetings, the legal assistant, who is, pretending to be a lawyer, I guess, suggested that the wife also sign a will because she didn't have a will. So we get to the meeting where the documents are signed and the wife signs a separate property trust, a deed to transfer her separate property house to the trust, and a will. And she didn't read the will before signing it, but the will was a standard pour over will, meaning that it didn't just pour over separate property assets, but poured over all of her assets to the trust to avoid probate. So you see how we have an ambiguity or mistake here. On the one hand, she wants an estate plan for her separate property. On the other hand, she's signing a will, which pours over all of her property into this trust. So she signs the document, years pass, and she passes away. And after she passes away, these documents come to fruition. And her husband files a petition to reform the will to say that it pours over only her separate property into the trust, not all of her community property and other assets. And the trial court under Duke granted the petition to reform the will and determined that the will only pours over her separate property into the trust. The Court of Appeal affirmed and said that Duke applies here. Basically, it wouldn't be logical at all to have a situation where you sign a separate property trust for the purpose specifically of holding your separate property house in a trust, but then you have a will that pours over all your other assets. Just doesn't make any sense, and it's totally illogical. The court also believed that it was important that there were never any discussions between the parties, or I should say between the wife and the legal assistant and the estate planning attorney, about community property or other assets. The only discussions were with regard to her separate property. So here you have an example of a Court of Appeal interpreting Duke and determining that reformation of the will was appropriate in this circumstance, because clearly there was a mistake. And if the mistake was to be enforced, her community property would go to unintended beneficiaries. Next slide, Ollie. So this case, the Eimers case, also deals with reformation of a will, but we have a different outcome here. Here the court determined that Duke did not apply and that the will should not be reformed. And what happened here is this case has to deal with, this case addresses powers of appointment. Now, I know you guys are most likely familiar with what a power of appointment is, but just to briefly explain, it is a power conferred in an estate planning instrument which authorizes the power holder to designate someone who will receive property under certain conditions. And in this case, we had a family trust executed by the dad, giving the parents' property in equal shares to each kid in trust upon the parents' death. And the trust provided that upon the death of each child, their share shall be distributed to any beneficiaries named in their will by specifically referring to and exercising a power of appointment. And so the son, the father's son here, executed a holographic will. Holographic meaning a handwritten will, which in turn means is most likely drafted by him and not by an attorney. So here, the will said, I give my shares of the trust to my friends. But the will did not use the words power of appointment. It did reference a trust, but it did not reference a power of appointment. And after the son died, the friends who were the beneficiaries under the holographic will brought a petition to reform the will to add the words power of appointment to the will. And here the court, the trustee of the family trust brought a demur to get the case dismissed. And the trial court granted the demur, dismissing the case because it determined that Duke did not apply and that the will should not be reformed. And essentially the outcome here is different than in the Wilkin case, which I just talked about, because here you actually have specific probate code sections on point dealing with powers of appointment, and those sections must be complied with. For example, probate code section 630 provides that if the creating instrument, which is here the trust, specifies requirements as to the manner, time, and conditions of exercising the power of appointment. Those conditions must be complied with. Probate Code Section 632 goes even farther, providing that if the creating instrument, here the trust, expressly directs that a power of appointment be exercised by an instrument that makes a specific reference to the power of appointment, the power can only be exercised by making that reference. Otherwise, it is invalid. And so here, the trust created by the parents required the decedent to specifically use the words power of appointment. The decedent needed to reference that phrase. And because the decedent did not do that, the purported exercise of this power was invalid, and his share fell back into the residue of the trust upon his death. Now, this outcome, I think, seems kind of harsh, because clearly he was trying to exercise his power of appointment, to give his share of the trust to his friends. And even the Court of Appeal admitted as such. It was clear that this was his intent. But the problem here is the Court of Appeal explained that his intent really doesn't matter. Duke does not apply, because here we have a situation where there are specific statutory requirements that must be complied with. And if you do not comply with them, basically you're out. It doesn't work. So, and the court was very concerned that these probate code sections would basically be nullified and eviscerated if they were not complied with. If otherwise, everybody would just come in with a petition to reform a will to make sure that a power of appointment is effectively exercised. So in some, where you have statutory authority that must be complied with, Duke does not apply, and rather the statutory authority must be complied with. So next, I'm going to turn it over to Kristen, and she's going to start talking about the exciting topic of taxes.
Thanks, Katie. Hope you've all had your coffee at this point. Good morning, everyone. So we're first going to cover for the 99.5% Act. Roberta will discuss the STEP Act a little later in the presentation. And just a couple preliminary items on this. Notably, perhaps President Biden did not discuss the proposed changes in the 99.5% Act in his discussion last week regarding the American Families Plan. So it's not really clear at this point whether these proposed changes will get any traction. And also, a majority of bills in the Senate require a supermajority vote. So, but if these proposals are rolled into a budget reconciliation bill, they can pass with a simple majority of 51 votes. So it'll be interesting to see how all of these estate tax proposals and capital gains proposals come together and in what form they will be in. So where we stand now, just as a real quick review, is we've got a unified estate and gift tax exemption amount of 11.7 million per person and a 40% tax rate. Under the for the 99.5% Act, we're going to see major shifts in those numbers. An estate tax exemption of 3.5 million and a gift tax exemption of only 1 million. In the slide, you'll note that the items marked with the asterisk are proposed to become effective after the date of enactment, whereas those without the asterisk will be effective on or after December 31st of this year. So those effective dates are also important as to the potential timing of when changes to your client's estate planning documents need to go into effect. So keep that in mind. For the 99.5% Act, the good news is portability will be retained. So we can expect that we'll continue to have that benefit going forward for married couples. The proposed tax rates also shifting pretty dramatically from 40% to graduated rates of 45% to 65%. And in the handout, you'll see the categories of those rates. We've got estates over 3.5 million, but not exceeding 10 million will be taxed at 45%. Those estates over 10 million, but not exceeding 50 million at 50%. Over 50 million, but not exceeding 1 billion will be at 55%. And those estates exceeding 1 billion will be taxed at 65%. Also, we've got the potential for substantial minimization of family limited partnership discount planning opportunities. There will be an elimination of most minority interest discounts and many marketability discounts for passive assets. Intentionally defective grantor trusts will be included in the transferor's estate unless they're grandfathered. This change applies to transfers made not only to new trusts after the effective date, but also to transfers made to existing trusts after the date of enactment. GRATs may be required to have a minimum 10-year term and a 25% minimum value for the remainder. This essentially will render GRATs really useless in most situations. And then annual gift tax exclusions, which currently are $15,000 for any donee and an unlimited number of donees. That number will shift to $20,000 per grantor total. We're not drilling down really in a detailed fashion on these proposals because, again, it's just proposed law. I anticipate the council will put together a much more detailed discussion regarding the changes that are ultimately enacted. Ollie, you can shift to the next slide. So as we have these proposed changes on the horizon, what should you be talking with your clients about now? In the title of the slide, Tax Me Now or Lose Me Forever, one of the big ones is for clients who have recent deaths in the family or deaths that occur in the near future, there should be some consideration, at least, to the benefits of taxing those assets now, as opposed to making the Q-tip election so that you can utilize the lower 40% tax rate and discount opportunities, as opposed to the potential of those discount opportunities going away and having much higher tax rates imposed. You also may be discussing with your clients making taxable gifts now. If we're looking at a $1 million gift tax exemption, that's a drastic difference between what we're looking at now with 11.7 million. We'd also potentially benefit clients by using the lower tax rate of 40% now. Another consideration is what to do with ILETs. These ILETs are generally funded. The premium is gifted to the trust on an annual basis. Doing that in the future, if the For the 99.5% Act is enacted, is going to result in those gifts to the trusts causing partial inclusion of the ILET in the transferor's estate. So you should discuss with your clients the concept of making a large cash gift to the trust now to pay for future premiums and avoid that partial inclusion. Otherwise, you may be looking at loan or split dollar type of arrangements in the future. All right, so I'll turn it over to Roberta now.
Next slide, Ollie. All right, let's talk a little bit about our federal transfer tax system as it exists. And we know that things may be changing right now. Kristen just told us about that tax act. I'm going to be telling you about another one that's in the Senate. But right now, what is the law? At the time of a transfer, there can be an estate tax at death. There can be a gift tax for lifetime transfers. And there can be a generation skipping tax, which is a separate tax, if assets are going down to a lower generation, grandchildren, great-grandchildren. And do you see on this slide any income tax? That's my big question for you. We don't have an income tax right now at the time of a transfer, but things may be changing, and this is a very, very big deal. Right now, we have income tax benefits. In the event of a death, basis goes from cost all the way up to current value. So I'm looking at Valerie's picture here. Valerie, if you have an estate selling a home in probate, you might have the wonderful opportunity to tell those children that there won't be capital gain on the lifetime gain of their parents because there is a stepped up basis. Well, what about gifts under current law? If you receive a gift from your parents, you're going to take their income tax basis. You don't get a stepped up basis on a gift. It just carries over to you. And one day, if you go to sell that property, you're going to report the gain since you obtained the gift with the carryover basis. So again, no income tax on this slide. Ollie, let's go to the next slide. What are our exemptions? Here, I hope I'm preaching to the choir. In 2009, it used to be 3.5 million. So what is the proposed bill, the 99.5% bill? It's proposing going back to what it was in 2009. In 2011, it jumped up to a $5 million amount that could be passed on tax-free at death. Now we're up to 11.7 million. And the law says in January 2026, the exemption will go back to $5 million plus inflation, which makes it about a $6 million exemption. So as Kristen said in President Biden's speech last week, we didn't really hear him talk about lowering the exemption. Well, one of the reasons may be it's going down anyway. So the government doesn't have to change it, it will go down. And 2026 sounds like a big year far away, but it's not. It's, within 5 years. The current rate of tax is 40% on anything over the exemption. Ollie, let's go to the next slide. There's Bernie. I don't want to step on your toes, Kristen, but once again, there's Bernie proposing that we go back to a 3.5 million estate tax exemption and the old $1 million gift tax exemption or exclusion. That's what it used to be. And of course, the rate of tax would go up. So we are living in changing times. Let's go to the next slide, Ollie. What's not changing is that there are certain elections that can be made on an estate tax return. So in handling the transfer of assets after a death, in administration of the estate, we're worried, should we or shouldn't we be filing an estate tax return? And the law generally says, if you have a gross estate, don't subtract the debts, the gross estate is the exemption amount right now, 11.7 million or more, we have to file a tax return, a Form 706. And if it's below that amount, we don't have to file a federal estate tax return, but we still might want to. And why would we want to? There's an election called a portability election. That's going to exist. And as Kristen pointed out, they're not talking about touching that election. So a decedent can transfer their exemption, right now 11.7 million, to their surviving spouse by making an election on that estate tax return, even if the estate doesn't have to file because the estate is under the 11.7. If the return is filed and what is called the DeSuey election, the deceased spouse's unused exemption, if that box is checked, it's a couple of boxes and a couple of lines, that exemption amount is transferred to the surviving spouse. And that's huge, an $11.7 million exemption, especially if our exemptions are going down. They are going to be going down. So you can lock in that deceased spouse's exemption. And to say it again, it's not automatic. You would think it's automatic. The public thinks it's automatic, that I just get that. But you have to file the return. The return is generally due within 9 months of death. Ollie, let's go to the next slide. So we have many cases that came out in the last year where somebody did not file the federal estate tax return. Later, they woke up for some reason. Maybe they saw an attorney or a CPA who told them, oh, you should have filed the estate tax return and elected portability. So now we have some letter rulings saying that there can be an extension of time granted to elect portability, even if you're doing it late, if the estate tax return was not required to be filed. So right now that means an estate of under 11.7 million. And for a married couple, if that's community property, their combined estate could be, 23.4 million. And they would not have had to file. So in very big estates, sometimes this is overlooked. So if it wasn't required to be filed and the trustee or the executor acted reasonably in good faith. And what are the cases saying is acting reasonably? Your lawyer forgot to tell you, your CPA forgot to tell you, or didn't even realize it was an issue. So in other words, you relied on an advisor, you were acting in good faith, you were trying to get good counsel, but somehow it didn't get filed. And if that's the case, you can go ahead and request an extension of time to make the election if you're filing within 2 years of the decedent's death. If it's over 2 years, we now have letter rulings that you can go in years later and ask that you be able to make this portability election. So this is good news for trying to clean up a mistake. Ollie, let's go to the next slide. The other election that's made on a Form 706, even though Kristen has said you might not want to make this election in the future, going into the future, is called a Q-tip election. And what is that? If there's a trust for a spouse, there's an election that can be made to defer the estate tax on that trust until the survivor dies. And so this was passed quite a long time ago. I think it was 1982. It was really a long time that we've had this Q-tip election. And in most estates, families do want to defer the tax that might be owing when there's a trust for a spouse. And then that property is taxed when the spouse dies in the spouse's estate at the value it has at that time. And why were people wanting to elect to defer the tax? Because the exemptions kept going up. I could show you a chart here that goes back to, 1976, what the old exemptions were. It was like $176,000. So always going through time, the exemption has been going up. And now there's discussion about the exemption going back down. And maybe the election to defer wouldn't be a good idea in that kind of an environment. But where we have decedents who have already died, the tax law hasn't changed. We're sitting here with estates that we have to administer. We still have to decide, should we elect the Q-tip election and allow it to be taxed later, or should we tax it now? One of the advantages, even though we're going to rethink it if the law changes, is if we elect the Q-tip election, those assets will get a new basis, maybe, when the surviving spouse dies. And as I say, all this right now is kind of up for grabs. We're juggling right now because we have a variety of tax bills that are, we're facing. What's going to change? It's like we're in a perfect storm. If you ever saw that movie, there's the boat tossing around and the waves are coming. We don't know exactly what's going to happen, but we may have to rethink it. Well, if you're going to make the Q-tip election, the return has to be filed. People think I'm entitled to this. Why do I have to file a return? So many people haven't filed the return. Ollie, let's go to the next slide. So for the people that never filed the return and say, geez, I wish I had made the Q-tip election, now we have letter rulings that there can be an extension of time to make a Q-tip election. What does the executor or trustee have to show? They relied on their attorney. They relied on their CPA who did not tell them to do it. You know, we don't want to hear this, but that's what the basis of the election is going to be. And so if you can come in and plead for mercy that my advisor didn't tell me, you may be granted time to make a Q-tip election. And there are a lot of letter rulings allowing a late Q-tip election. Let's go to the next slide. What about making gifts in our current tax environment? Well, we know we have an $11.7 million exemption. And it's kind of frustrating to know that a lot of that exemption is going to disappear when we go back down to a $6 million exemption in 2026. So people are saying, shouldn't I use my exemption now? It's going away. 2026 is almost here. And I say, good idea, but let me tell you the bad news. If you want to give away your exemption that's going away, the disappearing exemption is 5.7 million, which could result in a $2 million tax bill. If you want to give away, you know, the fat on top of the gravy, you're getting a clue here. See, I'm in the kitchen and there's my gravy separator. And I just want to get rid of the fat. I want to give away my 5.7 million before it disappears. Well, you have to spend from the bottom up. You have to spend your whole exemption. You got to get past the 5 or 6 million to get up to the 5.7 million. But yes, you can make a very large gift. You have to really get up there into that 11.7 million range. And it will not, the gravy or the fat will not be clawed back into your estate at death. If you made such a huge gift, it's gone. Fantastic. But who can really make such gifts? Well, clearly, highly affluent people can make such gifts. But when I'm living through changing tax environments, I find that people are nervous, they're unsettled, they're worried, they feel like they've got to do something, they've got to do something. And we saw this back when there was talk about losing the $5 million exemption. And we had people coming in saying, I've got to give away $5 million. I'm going to lose my exemption. I've got to do it right away. It makes people feel better that they're doing something, even if it's not a good thing to do. So you have to deal with this urgency that people are going to have. What should they do? And I was doing just some, quick math on a pad. And I've pretty much concluded that unless somebody after the gift is going to have about a $12 million estate left, they may not have enough to live on. It's kind of shocking. But if you have a 70-year-old, many of our 70-year-olds are living right now to 95. I've got so many clients in their 90s. I have clients who are over 100 years old. Not a lot of them, but what I've seen is many, many people live into their 90s. And people have to think about, what's the cost of living? Are we facing inflation? How much do they need? So if people are feeling, I've got to urgently do something, help them realize how long they might live and what it might take for them to live on. All right, what is our next slide? It's still me. All right, the proposed STEP Act. So remember on that chart when I said you don't see an income tax, do you, on transfer taxes? Well, guess what? We now have the proposed STEP Act. I love the name of these laws, Sensibility, Taxation, and Equity Promotion Act. This is right now in the Senate. I think it's the kitchen sink of laws. They're throwing in everything they can think of to try to increase income taxes. How it's going to affect trusts and estates if it's passed, we don't know. Is it going to pass? Is that at death or a gift, capital gain will need to be realized or recognized. What does that mean? It's like there's a forced sale. So if you want to transfer a property to your children, right now, you can do that. You pass on your basis. They take your income tax basis, and if they ever sell, they're going to have to report income. Under the new proposed act, the very act of giving will be a taxable event. You're not getting any money, but you're going to be charged a capital gains tax on the capital gain that's inside of that gift. And the capital gains tax rate is proposed to go up to, somebody tell me, 39.4%, with the Medicare tax of 3.8% on top of that. So we're at 44% on a capital gains tax, even though they're saying it's only if it's over $1 million. So we're talking about a lot of capital gain. But the very act of giving something will make it subject to income tax. And at a death, when usually you're getting that new stepped up basis, you know, the silver lining, all the capital gain goes away. There will be a capital gains tax at a person's death at that same high rate. So all of a sudden, the income tax comes zooming in as a transfer tax. And if it's on capital gain over $1 million, that's going to affect a lot of people. Think of homes in San Diego, how much capital gain is in there. Stock right now, that has gone up quite a bit. So we're worried about carryover basis going away and a gift or a transfer at death being subject to income tax. The exceptions that are built into the STEP Act are transfers to a spouse, either outright or in a Q-tip trust, transfers to charity, which is going to make Ollie Bean very happy because many, many people are going to be looking at charitable remainder trusts, gifts to charities to deal with this looming income tax. And the scary thing, who knows if this is constitutional, is if they pass the law, it would be retroactive to this January. So people who are making gifts right now, relying on our current law, could be trapped inside the new law. I find it hard to believe that will pass, but that's what's written into the proposed STEP Act. And now I think I'm turning it back over. You see, I dropped my agenda. It's on the floor. I'm not looking at it. Yes, we are. So please take it away.
Thanks, Roberta. So I'd like to just quickly clarify one of my comments on the For the 99.5% Act. I combined two of the proposed changes. One is that the Act confirms that intentionally defective grantor trusts are included in the transferor's estate. That's something that most of us estate planning practitioners know to be the case. There's a slim minority of practitioners that have tried to argue the opposite. So the For the 99.5% Act is confirming that. For the 99.5% Act would also include grantor trusts. And I made the comments about ILETs are one type of trust that at this point are not included in the transferor's estate. They're estate tax planning strategies. So For the 99.5% Act confirms intentionally defective grantor trusts would be included in the transferor's estate, and grantor trusts would be included in the grantor's estate. So just making that quick clarification before we jump on to the estate of Mary P. Bowles, which discusses when is a loan a taxable gift. In this case, Mary had 5 kids. She was generous with all of them, and she was a meticulous record keeper. She made regular gifts to her children. She kept records of how much went out, how much was repaid. And generally, if an amount remained outstanding at the end of the year, she'd write off the balance and forgive the debt based on the gift tax exemption. This arrangement would have been fine, but for Mary's treatment of her son, Peter. Peter followed in his father's footsteps, became an architect, took over the family business. His career initially showed promise, but things just didn't go on that trajectory. And as things slowed, he needed cash, and who did he look to but good old mom? So among many transactions between Mary and Peter, Although Peter already owed almost $160,000 in back rent to Mary's trust, Mary allowed Peter to use her trust as security for a $600,000 loan. And what do you know, when Peter couldn't pay that loan back to the bank came calling and ultimately held the trust responsible for that. In 1989, as part of her estate planning, Mary created a revocable trust, which specifically excluded Peter from any distribution of her estate upon her death, likely in consideration of the amounts that she had already gifted to him. Nonetheless, a few years later, Mary pays another almost $200,000 on a loan that Peter had taken out. In 1994, Mary amends her trust again, no longer excluding Peter, but instead providing a formula account for the loans made to him. And loans in quotes is used in the trust. Peter subsequently signs an acknowledgement that he did not have the assets nor the earning capacity to repay any or all of the amount that Mary had loaned directly or indirectly to him. And he agreed that the loans, together with interest, would be taken into account for purposes of distribution of Mary's trust following her death. Overall, Mary transferred over $1 million to or for the benefit of Peter between 1985 and 2007. After Mary's death, the IRS takes the position that these amounts going to Peter were adjusted taxable gifts that needed to be included in Mary's estate. Both, and then the estate obviously claims, no, these are just worthless loans. Both the estate and the IRS relied on factors in Miller versus Commissioner in determining whether we're dealing with loans or gifts. I've outlined these in the handout. Some of the factors are whether there was a promissory note or other evidence of indebtedness, whether interest was charged, whether there was security, a fixed maturity date, a demand for repayment had been made, actual repayment was made, the transferee had an ability to repay the loan, the transferor recorded or had maintained records that reflect the transaction was a loan, and the manner in which the transaction was reported for federal tax purposes is consistent with a loan. The Miller factors are not exclusive in making the determination of whether these transfers are loans or gifts. The tax court considered that in the case of a family loan, it's a longstanding principle that an actual expectation of repayment and an intent to enforce the debt are critical to sustaining the tax characterization of the transaction as a loan, as opposed to a gift. So Ollie, you can hit the next slide for the conclusion, is that the loans from Mary to Peter, or the transfers from Mary to Peter, were deemed to be loans. It was clear to Mary by at least 1989, when she created her revocable trust and omitted Peter as a beneficiary, that Peter was not going to be able to pay back the loans. Mary, when she realized that he would not be able to pay back the loans, she could have simply forgiven the loans. And the court considered that possibility, but found that Mary accepted that the money could not be repaid. She never noted in her meticulous record keeping that the loans had been forgiven, and she also didn't demand repayment or cut Peter off. To the contrary, as many good moms do, she kept giving him money, but that ended up causing some problems with estate tax purposes. All right, and so we'll take it to the next slide, Ollie. Okay, in Sachs versus Sachs, we deal with more gifts from very generous parents, and when a lifetime gift is actually an advance on an inheritance. So in this case, Dad created a trust distributing the bulk of his assets in equal shares to his two children upon his death. He maintained handwritten papers that he referred to as the permanent record, reflecting these lifetime gifts. he told his bookkeeper that he maintained the list of payments to his children so he could, so the payments could ultimately be deducted from their inheritances. At the end of the day, the son received in excess of $450,000 more than the daughter. So following dad's death, daughter's acting as successor trustee of his trust. She petitions the court for authority to treat the lifetime gifts as advances and to equalize the trust distributions between son and daughter. Next slide, Ollie. So the court looked at probate code section 2135 to determine whether these distributions of monies between the son and the daughter would be considered an advance on an inheritance, as opposed to just lifetime gifts that did not need to be equalized. Though in these situations outlined in 21-135, the transfers of money are treated as an advance. If the trust or the will provides that these lifetime gifts are to be deducted from inheritance, there's a contemporaneous writing by the transferor that a lifetime gift is to be deducted from the inheritance. The beneficiary acknowledges in writing that a lifetime gift is to be deducted from the inheritance, or the gifted property is the same property that's identified in the trust or the will. Here, the Court of Appeal concluded that the lifetime transfers were advances that needed to be equalized post-death. And looking at the factors in 21-135, the permanent record that dad kept appeared to be contemporaneous in that the entries were made in different pens, written on different types of paper, and keeping such a record really served no purpose other than to ultimately provide for the equalization of the trust distributions. The court found that there was no special form required for that type of record keeping, and the settlor's signature was not required. Additionally, looking at the factors, the son had acknowledged in an email to the daughter, after at least one transfer from dad, that payment would go on his record. All right, so we'll turn it back over to Katie.
All right, thanks, Kristen. The next two cases I'm going to talk about have to deal with attorney's fees, and I'm going to kind of race through them because I suspect that you guys are more interested in hearing about taxes and more on current proposals and current laws. But in any event, in the Medico case, that is a financial elder abuse case, and the decedent, her niece, brought a lawsuit against the nursing facility where her great aunt lived. And apparently the nursing home had purchased the great aunt's house for only $66,000 and in exchange agreed to give her free rent for the rest of her life. And one of the employees also obtained the great aunt's power of attorney and transferred all of the great aunt's money to her personal bank account. The niece got wind of this, filed a lawsuit against the facility, and during the course of the proceedings or sometime before, at some point, the money was returned to the great aunt, the money meaning her bank account money, not the house. But in any event, the lawsuit proceeded and the niece won on her claim for financial elder abuse. However, the court did not award her any compensatory damages or actual damages. So the trial court determined, yes, there's financial elder abuse here, but you get zero damages. But under the financial elder abuse statutes, even if you get zero damages, if you prevail on your claim, you're still entitled to an award of attorney's fees. So here, the trial court awarded the plaintiff over $100,000 in attorney's fees, even if she did not get any award of damages. And the nursing home appealed that ruling, arguing that basically the plaintiff was not a prevailing party because she didn't prove any damages. And because she didn't prove any damages, she should not be awarded attorney's fees. The Court of Appeal disagreed with that argument and affirmed the trial court. Basically, when you are litigating under the financial elder abuse laws, actual or compensatory damages do not matter. In order to prove financial elder abuse, you need to show that basically that a person has or entity has taken, secreted, appropriated, or obtained real or personal property of an elder for a wrongful use or with intent to defraud. That's all that you have to prove. You do not have to prove that as a result of those actions, damages were caused. So if you prove those elements, regardless of whether there are any damages or the situation was rectified, you are going to be entitled to an award of attorney's fees under the statute. Your award is mandatory. So that's very important if, for example, you have other claims in a lawsuit. If you can tack on a claim for financial elder abuse, even if you cannot show any damages, you'll be able to get your attorney's fees awarded. So that is always something that you will want to keep in mind. Next slide, Ollie. All right, so in the Shine case, this case also deals with an award of essentially a mandatory attorney's fees. And here we have a case where the Attorney General was involved as the petitioner or the plaintiff here. And the Attorney General typically gets involved when it feels like, at its discretion, in charitable trust enforcement actions. Typically, we don't see the Attorney General get involved a lot, but from time to time they do in egregious situations which affect charitable trust interests. And here, the Attorney General sued a trustee of a charitable trust for breach of fiduciary duty and accounting and removal. And the Attorney General prevailed on 7 of its 19 claims for breach of fiduciary duty, meaning the trustee prevailed in defending on 12 of the 19 claims. Still, even though the trustee was relatively successful, the Attorney General is also successful because it prevailed on 7 of the 9 claims, and as a result of the litigation, the trustee was ordered to pay $1.4 million in damages to the trust. And the trial court found that the trustee was grossly negligent by, for example, failing to take action regarding the loss of favorable tax treatment for trust property, failing to maintain trust property, loaning trust funds to friends, filing incorrect tax returns, permitting his daughter to rent out a property at below fair market value rent, failing to maintain trust records, and the like. So after the award, after the case was adjudicated and the award was determined by the trial court, the Attorney General brought a motion for attorney's fees. And under Government Code Section 12598, the Attorney General shall be entitled to recover attorney's fees in a charitable trust enforcement action. And so the Attorney General brought his motion and they won, of course, because the statute says shall. And so the Attorney General was awarded $1.6 million in attorney's fees. So essentially the trustee had to pay damages to the trust of $1.4 million and pay the Attorney General's attorney's fees of $1.6 million. The trustee appealed the order, the attorney's fees order, and the Court of Appeal affirmed. The trustee argued that the trustee acknowledged that this statute says shall, that the Attorney General shall be entitled to attorney's fees. However, the trustee argued that the trial court was required to perform an effectiveness test, meaning the trial court was required to consider the goals and results of the Attorney General. And here, because the Attorney General did not prevail on many of its claims, the trustee argued that the fee award should be reduced or eliminated altogether. And the Court of Appeal disagreed and said that the trial court does not need to do an effectiveness test, and the award is mandatory. So, in these types of situations, parties really need to be careful if the Attorney General is involved, because not only do you have your standard compensatory damages that could be awarded in probate court, but if the Attorney General is involved, the Attorney General can get an award of attorney's fees. And this case clarifies that that award is mandatory, and the trial court does not even need to consider the results of the litigation. So next slide, I'm turning it over to Roberta.
All right, more taxes. We're talking now about property taxes on California real estate. And you probably heard about Proposition 19 and what happened, but we're going to go over it because it's very, very important. In Proposition 19, if you read only the beginning of the proposition, it talked about people over 55 years of age, seniors, moving to another residence. And it all sounded very nice. But if you kept reading and reading, and I'll tell you, it took me 2 hours to read Proposition 19, you move along and you find out that what is being changed is the parent-child exclusion. So let's talk about what was the parent-child exclusion until February 16th, when Proposition 19 became effective. What it used to be is that a parent could transfer to their children their primary residence of any value at all, and there would be no change in the property tax bill. The children would take their parents' property tax base. And you can't believe, when we were doing estate administration, looking at a child's face when we're telling them that your property tax bill will not change. You get mom's property tax bill. They were so ready to sell the house, and now they go, whoa, 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 wait a minute. You mean I could even rent it and still pay that low property tax bill? And I would say, yeah, that's what the law says. And in addition, if a parent wanted to transfer other property in California to children, they could transfer $1 million of assessed value, that's property tax value, on the property tax bill, that lower, not fair market value, but what we call the Prop 13 value. They could transfer that much of other property to their children, and there would be no change in the property tax base or property tax bill. So that would cover rental properties, commercial property, raw land, you name it, any other kind of property, real estate here in California. And that was very nice. And that parent-child exclusion came through decades and decades of legal history that it was developed here in California. And then boom, Proposition 19 is passed. So Ollie, go ahead and change the slide. Beginning this February 16th, it seems like eons ago, but just a few months ago, the law changed on property taxes. What happens if a parent transfers their residence to children? Do the children take the parents' property tax base like before, even if they rent it out? Well, only if a child moves into that home and uses it as their primary residence, or if it's a farm. And up here in North County, we do have some farms. But for most people, we're talking about a dwelling, a residence. So if a parent wants their child to continue to get their property tax bill, or if the child wants to continue, they've got to move into the parent's home and live there. And that is no longer going to be a change unless the fair market value of the home is more than $1 million over the assessed value, more than $1 million over the property tax bill. So for somebody who's lived in California a long time, you could have a home that's now over $1 million more than your property tax base. In those cases, the amount over the million will be reassessed. So the big deal here is the child has to move in. It cannot be a rental property. Well, what about the right side of this slide? What happened to the other property? What about the rental property and the raw land, the commercial property? Reassessed, period. There no longer is a parent-child exclusion on the other property. So if children inherit, I'm just going to say an apartment building, their cash flow may be drastically affected because now the property tax bill is going to be that 1% of the current fair market value. It gets reset. So this is a very gigantic change in our property tax rules. And as Kristen reminded me, be sure to tell people that there is a California bill to try to delay the implementation of Proposition 19 for 2 years. I'm not sure if that's practical. I'm not sure if it'll pass, but it is in the works. But this is a very big deal. And if you're a financial planner, for instance, you want to help your clients think about what is the cash flow going to be after they've passed away on the real estate that they are leaving to their families. Let's go to the next slide, Ollie. We got to give you an example. So here, mom buys a home in 1990 for $200,000. The property taxes are $3,000 a year. Where'd it go? Where'd it go? There we go. If mom dies when the property's worth $800,000, that could easily happen, easily in San Diego. Before Proposition 19, the children could inherit the home and continue to pay $3,000 a year. But after Proposition 19, that's for any transfer February 16th or later, if no child makes this their principal residence, and principal residence means you're claiming the homeowner's exemption on that property and on no other property, then the property will be fully reassessed and they're going to pay $8,000 per year. And I say property taxes is the tax that keeps on giving year after year after year. So over 10 years, here the children have paid $50,000 more in property taxes. Personally, I feel Proposition 19 was kind of a stealth proposition that most people read the beginning of it, seniors moving to another home, and didn't keep reading. That's my personal opinion. Well, next slide. And here we have a rental property. So this is the other property in that slide. She bought it for $100,000. Now it's worth $700,000. Property taxes are $2,000 a year. Well, before Proposition 19, the kids could inherit it and continue to pay $2,000 a year in property taxes. But after Proposition 19, they're going to pay $7,000 a year. Over 10 years, that'll be $70,000. So it hugely affects property taxes here in California. Next slide, Ollie. Retirement plans. Here we are talking about something that was passed January 1st of last year. Why are we talking about this? Because I find a lot of people aren't aware of this. This has to do with what income taxes are assessed when money is drawn out of a retirement plan after death. And one of the reasons people may not know about it yet is because people they have to start dying after January 1st, 2020 for people to even feel the effect of what is called the Secure Act. It changed what happens after a death. So you might be familiar with the fact that under the old law, children could set up inherited IRAs if their parents left them a retirement plan, and the children could take required minimum distributions over their life expectancy. Maybe they'd only have to take out, 4% a year for many, many, many years. And while the money is still in the retirement plan, it grows without any current income taxes. Income taxes are deferred until there's a withdrawal. So we always say retirement plans are the goose that laid the golden egg. It's growing tax deferred. You always want to stretch out the period of time to actually draw money out of a retirement plan. Well, starting last January 1st, the laws changed. Who can use required minimum distributions? It is the spouse only and certain other, we call them eligible designated beneficiaries, EDBs. Who can use their entire life expectancy? A spouse, so no change there. A minor child until they reach the age of majority, a disabled child, that's fair, a chronically ill person, a person not more than 10 years younger than the person who died. So that could be their sister or their brother, that sort of thing. They can use RMDs. But for everybody else, those are non-designated beneficiaries, as in the kids. The kids now have a 10-year payout period. So that means when we're meeting with a family and we have children and they have an IRA, I'm going to tell them, go ahead, set up your inherited IRA through your financial advisor. And you do have to take your distributions within 10 years of death. And we've been saying that you can take it on the last day of the 10th year, which may not be a good idea because you'll have a giant amount of income at that point. Or you can take it throughout the period. And I've read an article, I'm not crazy about it. It says maybe you have to take required minimum distributions during the 10-year period because the old IRS instructions said that, but it's 10 years. And people say, well, that's not bad. I can't use my whole life. I can use 10 years, but it's part of your financial planning as the recipient. Who's stuck with a 5-year payout? These are estates that really blew it. If somebody didn't name a beneficiary on their retirement account, or they named their estate on the retirement account, or they named somebody who's died on their retirement account, then the plan must be withdrawn out within a 5-year period. In general, we say if you've named a trust, you're in the 5-year payout, but there are trusts called see-through trusts, where we can actually see through to who is the eligible beneficiary so that we can get a 10-year or a life expectancy payout. But the big shocker is usually for the children, that they only have 10 years to withdraw. So it's very important to review your designated beneficiary on your retirement plan. It's as important as your will and your trust and your power of attorney. Get a copy of your designated beneficiary. And people say, oh, I know, I named my spouse and my kids. I go, get a copy of it. You've got to keep it with your will. You have to see what it is because it really affects withdrawals. And next slide, I think we're going back to Kristen. There you go.
And I know we're running short on time, so I'm just gonna jump through these last 2 items real quickly. In Eiford versus Nord, we dealt with the situation when mental delusions negate testamentary capacity. In this case, Kay was really close with her granddaughters, something that we probably deal with our clients all the time. As somebody's nearing the end of their life and they need more assistance with finances, medical decisions, placement issues. Kay became very upset with her granddaughters and the way they were conducting themselves as it related to what she needed, and the help that they were trying to give her was not taken kindly by Kay, to put it lightly. Following Kay's death, so Kay, although she had initially left her entire estate to her granddaughters, in the year before her death, she changed her estate plan to leave the entirety of her estate to St. Jude to help sick babies, and eliminated Shannon and Aaron, her granddaughters, as beneficiaries. Following Kay's death, Shannon and Aaron tried to set aside her trust, Kay's trust, on the grounds that Kay was suffering from delusions as to Shannon and Aaron that caused her to devise her assets in a way that she would not have done otherwise. In other words, if Kay had been thinking clearly and not had been deluded by Shannon and Aaron and what they were supposedly doing out to get Kay for her money, wanting to lock her away in an assisted living facility, that if Kay had been thinking clearly and was not suffering from delusions, she never would have eliminated her granddaughters as beneficiaries of her estate. The ultimate conclusion of the case is that the contestant of a trust must prove the individual suffered from a mental health disorder in addition to proving that the delusions or hallucinations caused the challenged testamentary disposition. This is based on probate code section 6100.5A2. So although, you know, through all the testimony and the evidence that was put forth, it was unlikely that, well, none of the accusations that Kay had made against Shannon and Aaron were proved to be true. In fact, they were demonstratively false, the court found, but the granddaughters failed to prove that Kay was suffering from a mental health disorder. So the trust was upheld. All right, next slide, Ollie. And then finally, in Placencia versus Strasicic, hopefully I'm pronouncing that right, we deal with whether a will can invalidate a right of survivorship in a joint tenancy account. How many times have your clients come to you and said, you know, I'm getting up there in age, I need my daughter's help paying my bills, I'm just going to put her on my account and for convenience sake, but I don't intend for her to have that account. When I pass, I want her to share it with her siblings. That happens very often with my clients. So this case is just that. Ralph opened a joint bank account with one of his daughters, Lisa, that had joint tenancy with right of survivorship. Ralph, however, left clear statements in his will that he did not want Lisa to have that account entirely after he died, and instead wanted the proceeds of the account to go to his trust so that it could benefit all of his children. After Ralph's death, Lisa refused to relinquish control of the funds, received the funds from the bank by virtue of the joint tenancy nature. And as you can imagine, her siblings filed a lawsuit based on the statements in Ralph's will that he intended for those funds to be shared. This case involves really an analysis of the multi-party account statutes in the probate code sections, which are in the 5300 arena in the probate code. Generally, you can only change the terms of a bank account with the recognized methods of altering the joint tenancy nature, the beneficiary nature of the account. Ralph didn't comply with those recognized methods. However, the court kind of synthesized two of the multi-party accounts sections, 5303, which permits a bank to give account funds to the surviving account holder in accord with the terms of the account without risking liability. Banks can't, they need to be able to follow the terms of the account without worrying about ancillary documents and what they may say as far as estate planning is concerned. So the court synthesized that concept with section 5302, which permits a decedent's estate to bring a claim against a surviving account holder to the extent there's clear and convincing evidence showing that the decedent did not intend the funds to go to the surviving account holder, regardless of whether the recognized methods of changing that joint tenancy with right of survivorship actually were put into place. So in this case, the court held that the bank was correct to turn over the funds to Lisa pursuant to the terms of the account agreement, but the beneficial owner of the estate or of the funds, which was Ralph's estate, could bring a suit against Lisa to recover the funds. Interestingly, this account was $200,000. The resolution of this lawsuit required a trial, an appeal, and a probate proceeding that otherwise wouldn't have been required. So I'm sure at the end of the day, that $200,000 had been largely eaten up with attorney's fees. So just word of caution when you're discussing these types of arrangements with your clients, do your best to try to ensure that their estate planning documents are consistent with how their bank accounts are actually held. So that will do it for us. I think we might have some time for questions. And I know I've seen at least one item come up in the chat. I'd like you.
Kristen, sorry,
ahead.
I'm having a little trouble unsharing my screen. So what I'm doing is I'm just making you co-host for a sec. And I wonder if you could just briefly share your screen and then unshare it. And that should kick it out of looking at my screen.
It's telling me I cannot start screen share while the other participant is sharing.
Okay, hold on one sec.
Okay.
Try again.
Same thing.
Okay, let me, Katie, I might try see if you could do it. If not, all right, I'll try a couple tricks. But you can keep talking. I just I can't stop sharing the screen.
Okay, yeah, no problem. I'd like to, all of the audience, I want to take you in your handout to page 5, and I just want to drill down on what I tried to clarify earlier. On item D on page 5 of the handout, I want you to cross out IDGTs, which is intentionally defective grantor trusts, and write in grantor trusts. So for the 99.5% Act, includes a provision that grantor trusts, not intentionally defective grantor trusts. Grantor trusts would be included in the transferor's estate. So make that change. My apologies for the error. IDGTs are not included in the transferor's estate, and the 99.5% Act confirmed that. So the new proposal really is that grantor trusts would be included in the transferor's estate. Roberta, do you want to take over, or were you wanting to handle the questions and answers, or do you want me to kind of walk through them?
You can walk through them. I've tried to answer in the chat box or question and answers. I thought we're running out of time, but we've got some time. So go ahead and decide what questions we should.
Yeah, it looks like you've got them covered. Actually, they just went away. So unless anybody has a hand up or a question. I think we're good.
There you are, Ollie.
All right, we solved it. But it sounds like you have all the questions answered anyway. So maybe Bill, back over to you.
You bet. Hey, thank you all for attending. And of course, this was a power-packed 70 minutes or so that we had with our Hot Topic ladies. You know, the beauty of the Estate Planning Council and attorneys, CPAs, trust professionals, what have you, it is just the greatest group, very collegial. So in the outline that was provided to you all is the contact information for Katie, Roberta, and Kristen. And they, along with really anybody else that's involved with the council, or even Jonathan Blotmacher at the national level, they're happy to answer questions. So reach out and ask for guidance. And obviously, if we have situations that require an engagement, then you've got 3 great people that add to your arsenal. With that, certainly be looking for the meeting announcements for the June meeting, and sign up soon. And we look forward to seeing you then. Thanks so much. Thanks to Valerie for sponsoring and Ollie for running the show. Thank you all.
Thank you.